you, sir. Good to see you.
Hey, how you doing? Good to
Hey, ladies and gentlemen, good evening. I'd like to welcome you to the 15th Annual Bench and Bar Seminar and Reception. And tonight we've got a special program to you. We are featuring tonight the West Virginia Supreme Court of Appeals candidates, and all of them were able to attend this evening, and thank you all for coming. My name is Alex Messia. I'm going to be your moderator this evening. This event is brought to you by the Young Lawyers Division of the West Virginia Bar Association. And the actual director or chairperson of the Young Lawyers Division, a woman by the name of Rebecca Stevenson, is not here. She's actually on her honeymoon, which will explain why I used to be a young lawyer. So she asked me to come up here and be your moderator this evening, and I'll do the best I can. Before we get started with tonight's program, I'd like to thank some of our sponsors here, and obviously the West Virginia Bar Association, the Putnam County Bar Association, Kanawha County Bar Association, the West Virginia State Bar, and also some of our law firm sponsors here. And if you'll bear with me, the support of these types of groups are essential to our mission here at the Bar Association. We have Bowles Rice, Dinsmore and Scholl, Flaherty and Sensabaugh, Jackson Kelly, Kay Casto Cheney, Nelson Mullins, Riley and Scarborough, Harvey Payton in memory of Judge Spalding, then also the Payton Law Firm is a separate sponsor, Steptoe and Johnson, and also Spillman, Thomas and Battle. And last but not least, certainly West Virginia Public Broadcasting, who's set this thing up for broadcast on April the 10th at 7 p.m. This is also being live streamed now, which is of little use to you, I guess. But a couple of other announcements before we start is that the Bar Association is going to have two events upcoming, and that's the Real Estate and Business Law Seminars. That's going to be on May the 21st. We also have our 130th annual meeting at the Homestead. That'll be August the 4th through August the 6th. If you're not a member of the West Virginia Bar Association, I'd certainly encourage you to sign up. We have applications out front. Now we're getting onto the actual program at hand. There is one seat open on the West Virginia Supreme Court of Appeals. That election is on May the 10th of this year. There's only one election this year. We're all used to having partisan elections, that is primaries in May, and then the general election, where we select the actual judicial member, but we don't do that anymore. So there is only going to be one election, and as a public service announcement to everyone here, please remember to vote on May the 10th. The candidates, I will ask you when it's your turn to please pass the mic to each other. Make sure that we get a proper audio feed. Also that your responses to these questions, if you can keep them brief, 2 to 3 minutes. I'd like to have an opportunity also for members of the audience to ask some questions and bring their questions up to me. At which point, we have, or you should have, some 4x6 cards that were presented to you when you signed in this evening. If you have any questions that you would like me to direct to our candidates here, if you can please write on them. I have one of my colleagues will pick them up shortly. Let me just give a very brief introduction of everyone here. Starting here immediately on my left is Justice Brent Benjamin. He was elected in 2004, and his term in office ends at the end of this year. He is a graduate of The Ohio State University for both of his degrees. But prior to joining the court, he was a member or a partner at Robinson & McElwee for over 20 years. Next to him is Wayne King, who's been in private practice, solo practice in Clay County for approximately 45 years. He's also served as county prosecutor and family law master. His degrees come from, I think, West Virginia Tech, as well as West Virginia University. Next to Mr. King is Darrell McGraw, who was a graduate of West Virginia University. He served one term on the West Virginia Supreme Court of Appeals until 1988. Then he was our Attorney General from 1992 until 2012. Next to him is Beth Walker, got her degree at Hillsdale College, and then ultimately also at Ohio State University, her law degree. She worked for 20-some years as a partner at the law firm of Bowles Rice, and is now Associate General Counsel at West Virginia University Health Systems. And then last but not least, certainly, is Bill Wooten. Mr. Wooten has been in private practice in Raleigh County for a number of years. He also served some 26 years in the legislature, including 10 as the chairman of the Senate Judiciary Committee. So if you will join me, please, in giving them a round of applause, welcoming them. We'll start off with the questions. This is the first kind of introductory question to you. I'm going to start here with Justice Benjamin. Here, if you can please explain to us what is it about from your background, your work experience, or your education that makes you suitable to sit on the West Virginia Supreme Court of Appeals, and how does that, if at all, impact on how you view cases or pending before you?
As a sitting justice, I have a record of 12 years on the court. That is a record that people can look at and have a very good idea as to what kind of justice I will be in the next 12 years. As a justice, I believe in the rule of law and applying the law to the best I can in an impartial, independent way. And I believe that because of the efforts that we've made on the court, today we have a stable, predictable court, an independent court, and one that's viewed as fair. And that's what is so important. And I stress independent because that is truly what we need to have. A judge should not call balls and strikes before the pitch is even made. As I look out, I see many people many lawyers who've appeared before me, and I hope I've always been professional and collegial with you, because that also is an important quality in a justice. In addition to judging in an impartial way, it's also, I think, important to note that this job is about administration of our court systems in West Virginia. In that regard, I have helped lead the effort to take special treatment courts, being drug courts, veterans courts across the state. We are now coming up on 1,400 graduates, and those are people who've been able to turn their lives around, families that have been restored, and we've saved almost $20 million to $25 million a year in tax dollars just in saved incarceration costs. In addition to that, I began the state's Access to Justice program, and in 2008, took Steve Canterbury to Delaware so we could start the business court starting in West Virginia. And I'm happy to say it's been so successful that now Virginia has asked us for help to get theirs started. So when it comes down to it, in my case, you have a record, and that is the record I run on, and I'm very proud of it.
Thank you, Justice Benjamin. Mr. King.
First of all, I'd give a hand to the crowd that's here. It's a great crowd. I've been practicing law for 45 years in Clay, West Virginia, in Kanawha County, all over the state of West Virginia. I've appeared in front of numerous judges. I've appeared in front of the Supreme Court for some 40 years. I think that in and of itself gives an attorney a unique perspective on the law. We can talk about fairness, and we can talk about judging and everything else, but I believe that actions speak louder than words and everything else. I have very strong opinions about certain things. One of them is the public financing, which I disagree with. Secondly, I think we need to twerk the nonpartisan thing, so at least 50% of the voters have to elect a justice. I think we have to do something about that. Thirdly, I think that what we have to do is be open and honest and enjoy the practice of law. I think we forgot how to enjoy the practice of law. Yesterday, I was in an abuse and neglect case, this morning, an abuse and neglect case, and a summary proceeding this evening at 3 o'clock in Beckley, so I had to drive and scare my wife to death coming down the turnpike and everything else. So I'm still practicing law on a daily basis and trying to point these things out to the courts and everything else. I'm sad to say that the thing that I find the most is just the doggone arrogance of the judges and the Supreme Court when we go to practice with them and everything else. There's just an air of arrogance. I don't see Justice Benjamin saying anything about Justice Maynard and Don Blankenship when they're on the Riviera sunning myself. I guarantee you I will not be sunning myself on the Elk River or the Riviera with court employees. I'll guarantee you that. He talks about integrity on the court. I didn't see him say anything about a $13 million plane deal, but I don't know anything about that. I'm just a simple practicing lawyer from Clay, West Virginia, that'll tell you how it is. Justice McGraw, on my right, is certainly a great jurist, a great attorney general, but he got beat the last time he ran for attorney general, and he's going to get beat this time for judge. We have to understand, why is Daryl McGraw running? He only needs 1 year to retire. Why is he running? You know, Beth Walker, I don't practice health care, but I think there's more cases involving abuse, neglect, criminal law, and family law than health care in front of the Supreme Court, with all due respect. Mr. Wooten's a fine legislator and a great friend. But he took the public financing, so I have to say something negative about Bill, too. I'm the positive client. I'm the positive candidate. I'm asking for your vote, and that's what I believe in.
Well, thank you for your positive observation, sir. Mr. McGraw.
Daryl McGraw was privileged and blessed to be born in Wyoming County, West Virginia, where he learned in a family that service to the community was a paramount calling in our existence on earth. In that community, the duties imposed were keeping the faith and working through service. In that regard, I have been serving the people of West Virginia and of the United States of America in a definable capacity since I volunteered in the United States military at the age of 17 years. In the course of my service to the community and my belief that I strive to keep the faith, I served 12 years on the West Virginia Supreme Court. It was on that court that, in cooperation with other people, teams both intra-justice office and inter-justice office, we were able to work in the disposition of cases that came to the court and came to be noted as, in one year, noted and chosen nationally to be an outstanding appellate court in the United States, and we were all honored for that. In subsequent years, and Wayne, that's right, I was beaten in the ensuing election. In the years following that, I became Attorney General for West Virginia, and in that privilege and blessing to be Attorney General of West Virginia, we were able to work together there to recover for the benefit of the taxpayers of West Virginia $20 billion from wrongdoers who had taken advantage of our people. And the $20 billion went for numerous things in our state and community. One of the things that I've already heard discussed here this evening is the success of the drug courts. Mr. Wooten will remember that when the legislature did the laws that provided for community corrections alternatives, and they developed a program for day report centers or domestic violence centers or juvenile drug education, that the legislature didn't have the money to fund those things. And we knew that we could, through our actions involving drug companies who had done wrong things in West Virginia, fund those things from the recoveries. And we hear tonight from Justice Benjamin about how well those programs are working for the benefit of the people of West Virginia. I do believe that in pursuing one's duty and one's service, I believe in something that's, it's not a judicial phrase, but it's an admonition to all of us for the conduct of our lives, which is, which might be stated this way. I strive to do as much good for as many people as I can for as long as I can. And I see that opportunity through continued service, and that is why I'm running for Supreme Court.
Thank you, Mr. McGraw. Ms. Walker?
Thank you, and thanks to the bar associations and everybody who was involved in putting this event together. It's a great opportunity for all of us to be able to talk about this extremely important race for our next Supreme Court justice. It'll take place in just 40 days on May 10th. And I mention that every time because it's a very exciting change, I think, to have our judiciary finally be elected in nonpartisan elections. I ran, as I hope you recall, in 2008 for Supreme Court Justice, and I came extremely close. It was actually 0.6% from being successful in that race. And I talked about on the campaign trail a lot the importance of a nonpartisan election, and frankly, I was laughed at a little bit. Folks thought that could never happen in West Virginia, and it was just really exciting to see that it finally did. And our legislature last year in House Bill 2010 made this happen. But I remain concerned about our court system and about our judiciary. There are a lot of different examples, but just one is a survey of 800 general counsel from across the country that was conducted by the Institute for Legal Reform just last year. It's a survey that they do from time to time, and they asked those folks about the courts in all 50 states on a variety of factors that include enforcing venue laws, judicial impartiality, judicial fairness, and judicial competence. And in that survey that was just conducted last year and released in September, West Virginia ranked 50th. As a lawyer and as a citizen of West Virginia, I'm not satisfied with that result. I'm running because I think that a judge ought to very simply follow the rule of law and decide cases not based on who the parties are, not based on where you're from in West Virginia or who you know or on the politics, but simply based on the rule of law. That's what I talked about in 2008, and that's what I'm talking about again in 2016. We'll be electing a justice, of course, who will begin to serve in January of 2017 and serve all the way until 2029. And one way to look at that is that the folks who are in kindergarten right now, the children, will be seniors in high school when this justice completes their term. So it's incredibly important for the future of our state, and our state is in a challenging place right now, particularly in the southern part of the state, for a whole lot of reasons. But I think we need a court that is fair and impartial and perceived as such. And that's why I'm running. And I'm working really hard. We launched our campaign in June, and I've been traveling throughout the state. Of course, my background is with Bowles Rice. I spent a little over 20 years, mostly in the Charleston office, a little bit after I moved to Morgantown 5 years ago, handling cases statewide for all manner of different employers. I'm a labor and employment law. I'm proud to be having been elected to the College of Labor and Employment Lawyers, which is a national group. There's only a handful of us in West Virginia, actually, who are fellows in the College of Labor and Employment Lawyers. So I've got a broad variety of experience throughout the state, and now as Associate General Counsel for the WVU hospital system, I represent our now 8 hospitals. We're the second largest private employer in West Virginia, and I advise those hospitals on labor and employment matters. And we have a unique office, which is a really great opportunity because we actually try our cases in-house for the most part. We occasionally refer cases out. My litigation experience has only been enhanced by my work with the WVU hospital system. So I've been working really hard and trying to get the word out about the May 10th election, and I'm pleased to say that work is paying off. I've been really honored to have a number of endorsements from folks who, like me, are concerned about the future of our state. We announced our endorsement today by the West Virginia Coal Association. I've been endorsed by the West Virginia Chamber of Commerce, the West Virginia Business and Industry Council, and also the Farm Bureau, among others, all of whom agree with me that our court just needs to be fair and impartial. So I thank you again for the opportunity to be here, and I would very much appreciate your support.
Thank you, Ms. Walker. Mr. Wooten?
Thank you. My first job out of law school was law clerk to Judge John A. Field, Jr., and that was a real blessing. Judge Field was the ideal jurist. He's also a remarkable man, and I was fortunate to have that experience, and he's been my role model ever since. I've always wanted to serve the public in the role of a judge, and I think that was influenced by my association with Judge Field. Public service has been a major part of my entire life. Like many of you, I served on all sorts of local boards and coached local sports and all of those things. I also provided public service in that I worked in the prosecutor's office. In fact, working in the prosecutor's office, I claimed the distinction, I believe, of convicting West Virginia's most notorious living criminal. I convicted a man named Ron Williams for the murder of a Beckley police officer named David Lilly, and his notoriety comes from the fact that after he was convicted, he escaped from Moundsville and committed a second homicide, killed State Trooper Philip Kesner. You may remember that. But public service has been a large part of my life. I left the prosecutor's office when I was elected to the legislature. I served a total of 26 years in the legislature. As Alex indicated, 10 of those years I chaired the Senate Judiciary Committee. The Judiciary Committee certainly is not like a court, but it's not that far different. You deal with a number of issues, and you hear
competing sides on each issue. Instead of legislators doing the debate in West Virginia, it's evolved so that lobbyists pro and lobbyists con usually speak on issues. And I'm very proud of the fact that certainly you don't make friends every time you deal with something, but no one ever came away thinking that they were treated unfairly in a proceeding before my committee, and there was never any question about my integrity or my honesty. So I'm very proud of my legislative service. And I think that public experience in the legislature is good background for someone seeking public office on the court. When I was elected to the legislature, I began the private practice of law, and I practiced for many years. There is a television commercial now by Farmers Insurance, and the guy says, "We've seen it all. We've seen just about everything." And I think that would characterize my practice. I've been in every type of court there is in West Virginia. I think I've handled probably every type of case there is to be handled. And I think that kind of experience is an ideal qualification for the Supreme Court. Thank you for your time, and thank you for being here.
Yeah, thank you, Mr. Wooten. Before we go on to the second question, I just want to direct your attention to the fact that we do have brochures which contain complete biographies of everyone here. I didn't want to shortchange any of our illustrious candidates up here of giving them too brief of a background, but you should consult your brochures. They'll contain their full history. Before we go on, I'd also like to remind you that you do have your 4x6 cards, and if you could fill them out with some questions that you maybe would like for me to direct to the candidates here, then please do so. At the end of this next question, I'd like to have someone come up, and I do have someone come up and pick up your cards. So once you're finished, send all your cards to the end of your aisle, and I'll have someone collect them at the conclusion of this next question. Let's start on the far end this time. Mr. Wooten, we'll start with you, sir. It was already mentioned in response to one of the questions here that this is a historic election. It's a nonpartisan election. This is something very new for West Virginians, at least in the judicial field. We do have nonpartisan elections for boards of education. But what are your observations from the campaign trail as to how this, I don't want to say experiment, but at least this first time ever nonpartisan race in the judicial field is working? And now that you don't have the tag anymore, or the label really identifying you as a member of a particular political party?
Well, I've got mixed feelings. I think that the Code of Judicial Conduct pretty well made all judicial elections nonpartisan anyway. You're prohibited from speaking on behalf of a political party. You can't take sides in favor of a candidate. So they were basically nonpartisan anyway. I think the problem with judicial elections is that the voters, and I don't mean the people in here, most people have very little concept of what a judge actually does, and probably even less concept of what a justice does. So the more information they can get, the better served they are. So the label, I don't think, did any harm. On the other hand, being nonpartisan, I don't think does any real harm either. I'm concerned with the fact that we are probably going to elect someone with a minority vote. I don't know that that's bad. If I get more votes than anyone else, I won't care that it's less than 50%.
And we appreciate your candor.
But for instance, in my county, the legislature saw fit to authorize a Fourth Circuit judge. We don't have an incumbent. 10 lawyers are running for that position. Clearly, we're going to have a small minority winner. And I don't know that that's good. I don't know that we wouldn't be better off to do as some states do and have a requirement that you gain a certain percentage of votes, and if not, the top two do a runoff. But it's an interesting experiment. I think anytime you make major changes, there needs to be some tinkering afterwards. I think the legislature that made that decision will learn from our experience. I think it's working reasonably well.
Ms. Walker.
Well, I think I tipped my hand already in terms of my position on nonpartisan elections and thinking that they are important. I frankly think it's going to take a couple of elections to have it really change the way voters think about electing judges in West Virginia. So I suppose we're the guinea pigs, for lack of a better word, in this, what might be called an experiment. But I'm really optimistic about it. I think we are challenged, I think most, by trying to get the word out about the election being final on May 10th. You know, we've tried a lot of clever, the primary is our general. You know, you can only do so much with the hashtag Vote May 10th on Twitter. So I'm a little bit disappointed in the Secretary of State's office and the Supreme Court that the state hasn't done more to try to educate the voters. I'm not, you know, saying it's any person's responsibility for sure, but it is an incredibly important election. And when we are out in the counties talking to voters, there's very little knowledge about it. The local candidates are helping out a lot, the folks running for magistrate and family court judge, and we have a lot of, I know not in Kanawha County, but we have a lot of contested circuit judge races around the state. So the word is slowly getting out, but I think ultimately it'll be a good thing. I guess we'll find out what happens on May 10th and assess it from there.
All right, thank you, Ms. Walker. Mr. McGraw.
The development of the law, including the administration of justice, is an ongoing, developing kind of thing that we learn from through experience. And so we won't have a lot really to say about this first nonpartisan election in West Virginia until we've been through it. After that, we'll all, as we choose, have a say to the legislature, who, under the Judicial Reform Amendment to the Constitution, is the political body who makes the decisions on non-political elections. Thank you.
Thank you, sir. Mr. King.
I think I spoke earlier about my feelings about the nonpartisan elections. I'm not too concerned about it because I'm going to get 51% of the vote. So I'm sorry to tell you all that, but I will get a majority of the vote, and I'll be the next justice of the Supreme Court. It'll be like the king in his court instead of having the Supremes up there. But I like the nonpartisan idea. We have to reform it, and it will be reformed.
Thank you, sir. Justice Benjamin.
Well, I think as just a matter of common sense, it makes sense that politics should not have any part in the decision of cases. I'm very fortunate to sit on a bench right now where, to a member of the court, we leave the politics at the door, and that's a very good thing. Historically, that wasn't always the case, and I think that because of some of the concerns that the people have about their court, it makes a lot of sense, and I think the legislature was listening to the people when they said, let's go nonpartisan. I agree that we do have a problem with the May 10 not having a runoff. I think we're probably all in agreement on that, but we're running with the system that we have, all five of us. But I think ultimately politics have no place in the administration of justice. Certainly they do in the legislature and in the executive branch, where those branches are focused on policy. But I think that in the judiciary, it makes a lot of sense to just take the partisanship out. I think it's going to take a couple of election cycles to fully get everybody on board with this, because I think that in many cases what I see out there is the running to the party a lot still of folks when they're looking at running, because that's the way it's always been done. So it's going to take a little while for that to come through, but I will tell you, as a candidate, it's a lot of fun to be able to go to events, whether they be Republican, Democrat, Independent, whether they're civic related. I think it just makes a lot of sense that the candidates be able to do that and let everybody see all the candidates. So I'm in favor of the nonpartisan.
Thank you, Justice Benjamin. At this time, if you have any questions that you've written out on your 4x6 cards, if you can send them to the end of your aisles, and we'll have somebody collect them. Let's go to the next question. The next question, and we'll start off with you, Mr. King, is that the Supreme Court substantially revised the rules of appellate practice a couple years ago, and so that every appeal would get at least some kind of an opinion, be it a memorandum opinion, memorandum decision, or even a signed opinion. Is this process, at least from your perspective, working, or is it just simply kicking the can down the road, and that we really need to start thinking about an intermediate court of appeals, as was discussed previously? And in terms of your answers, I would also caution you that we understand the state does have budgetary issues, but setting that aside, since the court does control its own budget, let's think about, do we need a intermediate court of appeals, or does the new process work as it is? Mr. King?
I do not believe we need an intermediate court of appeals. I think the Supreme Court does a timely matter decide the cases with the memorandum decisions. I've sent many abuse and neglect appeals down to the Supreme Court, and they've sent most of them back, unfortunately. But it's just a process that I think that the present court does do a adequate job in a timely manner. And as I said, we do not need the intermediate appellate court.
All right, thank you, sir. Mr. McGraw?
An intermediate appellate court would ultimately just be a barrier to litigants at that level before they ultimately seek relief at the level of the Supreme Court. I don't believe it expedites the administration of justice. I do believe it would be a burden on the taxpayers, and I think that it would probably impede the admonition contained in the Constitution that justice should be speedy and without delay.
Ms. Walker?
On the topic of the changes to the appellate procedure and the memorandum opinions, memorandum decisions that are now issued, the concern I have as a practicing lawyer is there have been mixed messages from the Supreme Court about the precedential value of those memorandum decisions. That, as all of you know in this room, it's difficult to advise clients about cases, to make judgments about trying a case or appealing a case or filing motions when that guidance, in my view, has been a little unclear. So that's my concern about the change. I know that the Supreme Court has worked hard to try to implement that and issue all of those memorandum decisions, and I certainly respect that, but I don't think we quite exactly know just how much we can rely on them. On the topic of the intermediate court, of course, the legislature under our Constitution has the authority to decide whether there's an intermediate court. That's not a decision that comes from the Supreme Court. I respectfully think that the budgetary considerations have to go into that analysis. I think there are policy arguments to be made for and against an appellate court, but in the current budget crisis, I don't think that there's much ability to discuss that.
Mr. Wooten?
The modern judiciary amendment was adopted in 1974, and it expressly authorizes the creation of an intermediate appellate court by the legislature. In that time, no legislative committee has even reported such a bill out of committee. It's never really been taken up in the legislature. For every legislature from 1974 through 2016. In that instance, the legislature got it right. That might change at some point, but since the rules changed, the Supreme Court's averaged a little over 1,000 cases a year, and on an average, about 225 of those have been civil appeals. The rest are criminal or domestic or all sorts of things like that, administrative agency type things. It's a busy court, but it's a manageable workload. If government can accomplish its task with that level of expenditure without saddling the taxpayers with the cost of an additional layer of the judiciary, then the government should not do that. And that's what every legislature has determined since 1974. Thank you.
Thank you, sir. Justice Benjamin?
Well, I want to thank Mr. King for commenting about how fast we get our abuse and neglect cases turned around, because that is certainly an example of what our current court has been able to do. And certainly abuse and neglect cases get prioritized, and they should. That's the way it is. But as a court, our clearance rate is now at the highest level it's been in anyone's memory. We're getting the cases turned around very quickly. And the memorandum opinions, certainly that there are every once in a while there's some complaints, but overall, we've heard very positive feedback because now attorneys have things to have something in writing to show a client. Win or lose, at least there's something that shows how the court came to its conclusion. I think that's a very important thing. With respect to the middle level or intermediate court, the essence of it is that it will add another level of government, and there has a cost element to that. There are benefits to it, but it is ultimately a legislative determination. And I think in this case, the legislature weighing the pluses and the minuses made the right call. Now is not the time for us to consider a middle-level court. And I think as a personal aside, and I think Mr. Wooten might agree with me on this, the two of us have been involved in some litigation recently, and if we had a middle-level appellate court, we might still be waiting to find out what the result would be. So I think that certainly there's a importance to getting justice in a timely manner. And when I look at states around the country, and we look at states of roughly our size, what we see are many states that do not have middle-level courts or ones that have a hybrid. And certainly I would note that Delaware, where we learned how to run a business court, does not have a middle-level appellate court.
Thank you, Justice Benjamin. This next question, we're going to start off with you, Mr. McGraw. And what initiatives would you champion or promote if you were elected to the Supreme Court? And along those lines, I'm thinking about some of the things that we had heard earlier, such as alternative sentences, drug courts, business court, things of that nature.
Well, thank you very much, Ms. Walker. Let me speak from my experience with respect to that, both while I was at the Supreme Court as well as when I was Attorney General. We were very active in funding programs across the state, as I have already mentioned, from recoveries from wrongdoers. And we've been for quite a long time involved in, to use a broad term, community corrections that includes the different things we've talked about here, domestic situations, juvenile situations, drug situations. And I think that the experience beginning with, well, Cabell County and to a greater degree, the Northern Panhandle, where we had Judge Galvin, Marty Galvin, pick up the ball and run along with his chief probation officer, Jim Lee. And we were able to fund that to the degree that that they were looked at from afar and invited to participate in programs not only in West Virginia, but around the country. So I as a general proposition, support community corrections. Just using one example, the day report centers enable people who have been involved coming out of the drug courts to be able to continue to be with their families, to work in the community, to maintain their efforts to improve themselves. And as a general proposition, I think that community corrections programs, about whatever subtitle you may call them, are usually good things, not perfect things, but remembering that we don't live in a perfect world, and that a lot of folks have problems in this imperfect world, and we have a lot of successes. Some people will complain because there are failures, but we should be particularly encouraged by our successes.
Thank you, Mr. McGraw. Ms. Walker?
At the risk of being boring, I would just like to be a really good, hardworking justice. I think the focus should and will be, should I be fortunate enough to be elected, is carefully doing the work of being a judge. There are certainly important issues that the Supreme Court needs to address. Obviously, the administration of the drug courts, the veterans courts, the juvenile drug courts, the administration of the entire judiciary. It's all very important. We need to have excellent, extremely competent people in all of those roles. But I think a justice's duty, first and foremost, is to judge, to read carefully all of the briefs that are filed, to think carefully about the cases, to give the greatest respect to the folks to appear before the court, and never to appear to retaliate against those who appear before the court with a good faith effort for political reasons or otherwise. And so that'll be my focus.
Thank you, Ms. Walker. Mr. Wooten.
First off, I don't disagree with what Ms. Walker said. I don't know that I would bring any initiatives. I would say this, though. I was in the legislature when Judge Gahn and Mr. Lees came down and wanted legislation authorizing the community corrections program that Mr. McGraw mentioned. And that is an important program, and I was glad to be able to be in a position to assist in that. I've traveled the state, as these other folks have, in connection with the campaign. In Cabell County, I learned that they have a particular problem in Cabell County, and they've created what they call a woman's court, dealing with an issue that's not common in most of the state, but it is in Cabell County. Judge Gahn in the Northern Panhandle started community corrections in response to a problem there, and that has taken off. Lots of counties have emulated that. I think rather than an initiative from me as a member of the Supreme Court, I would like to encourage circuit courts to the extent they see a problem and a method to address that problem. I would like to encourage them to do that. I believe that one solution imposed statewide is not the best way to deal with the particular problems of each of our jurisdictions. Thank you.
Thank you, Mr. Wooten. Justice Benjamin.
The core mission of the courts, first and foremost, has to be administering the trials and the disputes that come before the court. And that is a challenge in a time when revenues are down. While it has been said that we control our budget, the reality is that 86% of our budget is non-discretionary, and that extra amount that is discretionary has to be done in a very, very careful manner because the state is having troubles right now. And so this term, we sent back about 10% of our discretionary budget to the state. And as we face budgetary problems, we're going to have to look at how we can do things better, more efficiently than even we're doing now. So first and foremost, we have to focus on the core mission of the courts, always. But that doesn't mean that we don't also look at other things which also provide wonderful benefits to the state of West Virginia and save more tax dollars than they spend. We're all, I think, hopefully in agreement that the drug courts have been a very successful program, but I can tell you, when I was knocking on doors back in 2006 and 2007, trying to get support, it was hard. But each graduate became an ambassador of the program. And as I said earlier, we're now coming up on 1,400 graduates with just over a 9% recidivism rate compared to almost 80% for a drug user who's simply incarcerated. And obviously, we don't send every person to drug court. In fact, if you're a bad person, you go to jail, and that's the reality. You only get in drug court if both the prosecutor and the circuit judge agree that you should be in there and that you can rehabilitate yourself. But the program has been very successful, and I'm happy to say that from those fledgling days back in 2005 and 2006, when we were counting graduates in the 1, 2, 3 range, we're now going to be statewide in all counties by the end of this year. And I think that's a wonderful accomplishment, and there's a lot of people that have had a lot of support and a lot of effort in that. But it comes down to leadership in these areas. We're only halfway there with juvenile drug courts. And we need to get the problem as early as we can, and some of our best examples of turnarounds of people's lives are in the juvenile drug courts. Judge Gahn got a letter I believe it was last fall, from a young man, and it simply stated this: "Dear Judge Gahn, thank you for helping me with drug court. I'm writing you this letter from the law library of the Wake Forest University Law School, where I just began my second year." That's something that is very, very important. And you multiply that type of a letter times the 1,400, and you're talking families, you're talking West Virginians, you're talking turning people into taxpayers again. And it doesn't stop there. We've got 4 pilot veterans courts in the state, and they've been very successful because it allows us to focus down on the specific causes for, in many times, the self-medication that leads to crime. And again, it's a matter of finding the resources, looking for federal dollars to the extent we can, looking for grant money. That's something that can't be done by a circuit judge. That has to take the leadership from the court itself. And we have to make certain that everyone is following certain guidelines, or else we won't know if our program's working or not. It's also about getting out and listening. As many of you know, I try to attend as many regional bar meetings as I can. And it was out listening to people that we found out that business courts might be something that might be successful here, and they have been. So, yes, the core mission for the court has to be the administration of justice in the form of cases and disputes, and making certain that abuse and neglect cases are handled as fast as they can be. But it's also doing the extra things that a judge sees that can be fixed in the correction system, in the sentencing side. And it's something that we as a court have to give support to our circuit judges for. And then there's one other area, and this is one that we don't talk about a lot, but I'm sure all of you who do abuse and neglect cases are very aware of it. We currently have over 1,000 children in our state in foster care who are available for adoption. And the statistics show us that the longer it is that these children do not have permanency, the more difficult their lives will be. A child over the age of 12 who does not have permanency in the form of a family they can call their own, and if that lasts more than 8 to 12 months, they have less than a 3% chance of graduating from college. That's not fair. That's not right. And it's something that we as judges can do, and something I believe should be done, and it's something that I will do in a next term. Thank you.
Thank you, Justice Benjamin. Mr. King.
Thank you. I see it on a daily basis, what you're talking about, Justice Benjamin, with regard to the abuse and neglect cases. I probably am in abuse and neglect cases 3 times a week. It's very, very sad in the rural areas here in West Virginia. And it's something that I don't know what the answer to is. We have to do something to get these kids into permanency and to try to get them adopted or get them into a family that loves them and tries to put them on the right trail. With regard to the drug courts, I think it's been a tremendous program. I think we have to expand the drug courts, though, possibly to even take in the alcohol first offenders and second offenders, where we can take the drug courts and these offenders and counsel them and work with them on a daily basis through the probation officers, and not be on the punishment side, possibly even look at decriminalizing first and second offenses when you're talking about drugs or alcohol, and go more to community counseling, the Alcohol Anonymous, programs like that. I think all those can work hand in hand together, and I think the court can have a leadership role in that.
Thank you, Mr. King. This next question will direct to you, Ms. Walker. The purpose of public funding for Supreme Court races really was to kind of level the playing field and allow candidates who didn't have a whole lot of money really to enter into the field and enter into the political process. One of the sitting justices today was the beneficiary of it, and that's Justice Lothry, who was able to overcome a lot more better funded campaigns, and now is, of course, a sitting justice. Is there anything wrong with that particular goal?
No. Excuse me. I chose personally not to participate in the public financing program because I can't in good conscience, given the budget situation of our state, run a political campaign on state funds. But the program is the law, and I respect the law, and I understand it's well-intended. I'm just not sure it's a luxury that the state of West Virginia can afford right now.
Mr. Wooten.
First off, I would take issue with the question. I don't think it was designed to enable candidates who otherwise could not afford to run. I think the public financing program was designed to restore confidence of the public in the impartiality of the court. I think that if litigants come before the court and the public is aware that this litigant financed the election of a judge or a justice, that undermines the confidence of the court. The way to restore the confidence of the public in the integrity and impartiality of the judicial system was to eliminate candidates like us seeking contributions from people that would be affected by our decisions. And as a practical matter, having been involved in a number of partisan political races, the only people that contribute really are people that have an interest in what you do.
Thank you, Mr. Wooten. Justice Benjamin.
Well, I agree. I think the premise is not entirely accurate with respect to leveling the playing field. The purpose in the legislation itself is stated to ensure or to help to ensure that any public perception of undue influence by out-of-state interests or special interests is minimized at the court. And that seems to be the primary reason that the legislature chose to take the pilot program that Justice Lawfrey ran under, and last year finalize it that was effective in June. And I would note that the financial problems of the state were known to the legislature last year. It was certainly something that we on the court was dealing with at the time also. And yet they believed that it was a necessary program, and it is a policy matter that they've made the decision on. It's also a program that was upheld by the Supreme Court. I was not on that panel, but it was upheld by the Supreme Court in 2012 in Justice Lawfrey's case. So I think that it's very important from that standpoint, but it's also important from one other standpoint. And I think sometimes this gets missed. And that is, it allows people, just as a way of background, in order to qualify for public financing, a candidate must have a minimum of 500 contributions of no more than $100 each from only West Virginia registered voters. And they must have a certain amount from each congressional district. And so it's rigorous. It's not designed to be easy. But in many cases, that person who's on a fixed income, who may only have $1 or $2, what public financing does is it means that they're just as relevant as the person who has $1,000 checks that they can hand out from whatever group that they come from. It means that that person who might be a senior citizen, that person who wants to participate and may never have participated in a race before because they simply didn't think they had the financial means to do that, can now participate. And if we consider this the people's judiciary, then that just makes a whole lot of sense also. And that last part doesn't always get mentioned, but I think, at least in my campaign, it was a very important aspect. One final thing also. As a judge, the public financing allows you to avoid having to seek money from the people that appear in front of you. Now, from your perspective, that's probably a good thing that you're not getting phone calls from my campaign, but it's a very important thing in a personal manner. And it doesn't mean that it's bad to do it the other way. I'm not going to criticize anyone who does it otherwise, but from my perspective, it was something that I was just not willing to do. And I'm not the first to do that. John McCuskey back in 1998 made that same determination, and as many of you remember, made the call that he was uncomfortable doing it also, so he did not take any attorney money in that situation. it is a means by which a judge can insulate themselves from either having to approach a lawyer who appears in front of them, or later on, when we have to decide tough cases, being attacked because maybe you took $1,000, your campaign did, even if you didn't know it. So it is a way to insulate. And so I think it's a very good thing. Ultimately, it was a policy matter by the legislature. They're the ones who are listening to the people out there. They're the ones who are implementing what the people wanted. It makes a lot of sense, and I think it's a wonderful program.
Thank you, Justice Benjamin. Mr. King.
From day one, I've said I'm adamantly opposed to the public financing. I did not seek public financing, and I will not ask any of you for any of your tax money or your personal money to fund my campaign. I'm going to be making a salary of approximately $140,000 a year. That's more than 90% of the population of West Virginia makes. Why should they fund my campaign? It comes down to a simple word, and it's called greed. They're taking money. We have two candidates here that have taken money from the legislature when we have a PEIA problem where my wife's insurance is threatened. If you took 55 counties of senior citizens, that's $18,000 to each senior citizen across West Virginia. That's $1 million that could go to court-appointed lawyers when we're struggling out there at $45 an hour, $65 an hour in court. I doubt Ms. Walker even goes to lunch for $65 an hour. But notwithstanding that, here we are taking that money. I'm not going to do it. I'm also make the pledge. I've told everybody that I talked to and everything else. I will not take one additional penny for financing costs that I incur while I'm Justice of the Supreme Court. I don't believe that's right either. If I can't live on $140,000 a year, I'm not going to be much of a judge. I'll tell you that right now. I think I can. I am adamantly opposed to public financing. Let's get real. Do you think that's really taking the money out of elections? Let's face it. There's always going to be money in elections. It just comes down to whether or not you trust the person that you're voting for. That's the only thing I can tell you.
Thank you, Mr. King. Mr. McGraw.
I heard one of the respondents to that question speak of the case in 2012, I think it was. I was I was requested by the Supreme Court to file a brief in that case on the issue of the legitimacy of this public financing. And the thrust of the brief done by my wonderful lawyer associate, Barbara Allen, was that this was an unconstitutional proposition. So from a personal point of view, any action that I might have taken to participate in that program would have made me hypocritical. So I labor under that difficulty. But I can tell you that there are a lot of strings running through that business and that there are a lot of shadows behind it. But on a lighter note, you may remember the Daily Mail of an editorial page a day or two ago in which they showed the automobile on the road and the potholes relating to, of course, the public finance. And it causes me to think of the 75 cents it would take to repair a pothole every time my automobile jars my teeth as we go over that pothole.
Thank you, Mr. McGraw. This next question's for, start off with you, Mr. Wooten. Would you support a further move toward alternative dispute resolutions? That is to say, non-binding arbitration, the early case evaluation with maybe judicial intervention, or something along the lines that would take us out of the typical litigation style and also the costs associated with that?
I don't know that we need to further move in that direction. If the need were demonstrated to me and I were on the court, I would not be opposed to it. But based on my experience at this time, I think that there's no need for an additional initiative from the court to bring more of that about.
Ms. Walker?
What I know has been really successful, just from my practical experience, is the alternative dispute resolution that we already have. The mediation, court-ordered mediation, has been a wonderful tool, both as a law firm lawyer and now as an in-house lawyer, gives us an opportunity, a reason really, to sit down and talk, sometimes early, sometimes before discovery, sometimes in the midst of it. So if there are additional improvements that can be made, you know, like Mr. Wooten, I'm certainly not opposed to it, but I think there's been real progress already.
Mr. McGraw?
In any litigation, there's going to be back and forth between the litigants and their counsel. And when we speak of alternative dispute resolution, I think of the constitutional provision in the West Virginia Bill of Rights. I think it's probably section, I know it's Article 3, but I don't remember it's 7 or 17. It says the courts shall be open to anyone who finds themselves injured in their liberty, their life, or their reputation. And I believe that that mandates that justiciable issues ought to be handled in courts by judges that are chosen to do that.
Thank you, Mr. McGraw. Mr. King?
The alternative dispute resolutions that I've been involved in have been maybe successful 30% of the time. I'm not opposed to the alternative dispute resolution method. I think it does have a benefit in some cases. I was involved in a summary proceeding today where the matter was settled in mediation. It was a very, very emotional situation. I would be open to anything that would allow the parties to save time and money in litigating their case.
Thank you, sir. Justice Benjamin?
I think mediation is something that should certainly always be encouraged. I think it should be, in many cases, up to the trial judge. I don't see the need for a mandated mediation program by the court. I will say this, though. When we were putting together the business court, we were listening to the litigants, what they wanted, and we were also listening to the judges of what they had seen from their experience would create a more efficient way to resolve problems. Because as many of you know who've done business court, the cases have to be resolved, or we try to resolve them within a year. And the litigants like that very much. And mediation has been something with judges involved that has been very successful in the business court. So it's been very successful there, but taking it out to the civil, to the broader civil cases involving consumer litigation and so on, I don't think it should be mandated. I do think that it's important to have it as an option, and the parties should always be encouraged to do that.
Thank you, Justice Benjamin. This next question, we'll start off with you, Justice Benjamin. Back at you. In your years of practice, but in particularly the last several years of as you sat on the bench, and to all of you here, you know, at least your experiences in the last several years, what are your thoughts on the biggest concerns facing litigants, litigators, or just generally the West Virginia legal system?
Well, first and foremost, we have a wonderful bar here, and for those of you who travel outside the state, I think many of you understand what a gem we have with the professionalism and collegiality we have as a bar. It is something that we should always encourage, and it's my way of taking my hat off to all of you who helped do that, because it is something that I think sets West Virginia apart. That being said, we do have challenges that are facing us. Challenges, first and foremost, probably on a short-term basis with the economics and the problem with revenue in the state. We have seen it in other states where they have pushed back civil cases because of the priority for criminal cases. We've seen layoffs in other states. And we're going to do everything we can as a court system to try to avoid that. But on the short-term basis, the budget is something that, from the standpoint of administering the justice system in West Virginia, is something that is the Supreme Court's first obligation. Longer term, the drug epidemic in West Virginia is something that none of us can ignore. It is hitting every family in some way or another in our state. We have great programs that are working, but we need more. In the court system, we are necessarily reactive. We see the problem after it's already manifested itself, after it's already been in law enforcement's hands, after it's been to the prosecutor's office, and then it comes to the courts. And certainly, the drug courts, the veterans courts have been an outstanding program that not only deals with the problem, but also ensures that we save tax dollars and make our communities safer. And that's a very important program. But we also need to work the drug courts in with other programs in the state. And in that regard, there was a comment made about the special emphasis in Cabell County on, and it's on human trafficking, women who have been caught up in human trafficking because of the drug trade in West Virginia. And I will tell you, it's bigger than anybody, it's bigger than I thought it was once I began talking to mayors around the state. These women, in many cases, and Mike Frazier knows this because he's been working with it firsthand, they don't have enough money to even buy toothbrushes, and they're kept on a very short, they're kept with almost no money available. And as such, and then they're forced into prostitution, forced into shoplifting, and the like. And it's an aspect that we didn't really see as a court or as judges. We saw the drug problem in its big form, but we didn't see it in the small form until we began listening and hearing what was the problem with the municipal judges on the front side and the counties. And by working with our federal delegation in Congress, getting grant money, we were able to double the size of the drug court in Cabell County to address this specific need, to try to get these women out of this situation, also to help their children, because these children are growing up in environments that are horrible. They're just horrible. And to get them back into a good environment. The drug problem is affecting us as taxpayers everywhere. In Cabell County, for instance, they had to start an entirely new neonatal ICU unit just because of the number of children being born with drug residue in their system. In some counties, it's been estimated that that may go up to 50%. And why is that important? Well, number one, the medical care is in many cases being paid for by the taxpayers of West Virginia. But it's also a problem that our educators are starting to just now see as these children are starting to come into our schools, requiring special education and more attention because of learning disabilities. And the big wave is just now, is not yet there yet. So as a court system, on the short term, we've got to deal with the finances. But on the long term, we're going to have to deal with the drug problem that's still there. And the good news is West Virginia is starting to figure out there is a drug problem. That's the first thing. And we're starting to realize it's a community problem that we all have to work together. It's got to be all hands on deck. But from a court standpoint, we're going to see increases of abuse and neglect cases, criminal cases, shoplifting, all of those types of things. And that's going to burden the system, and it's something that we're going to have to deal with.
Thank you, Justice Benjamin. Mr. King?
Thank you. Because of the financial difficulties we're having in the state of West Virginia, I see it in my home county, and we're the first county north of Kanawha County here on I-79. It's you have children being born in the hospitals with the drug problem, and it's kind of personal to me. My wife and I, our daughter, adopted a little baby girl that out in California that was born through the drug culture and everything else. But all these things have to be worked with in the court system. We have a great bar. We have a great jury system in West Virginia. I adamantly disagree with any survey that tells me that West Virginia does not have a good jury system and a good court system. We have the best there is, and I'm proud to practice there. And I hope to be able to do more in the future.
Thank you, Mr. King. Mr. McGraw.
Under our system of government, as we've outlined it in the Constitution, both national and state, the business of judicial, of financing the judicial activity runs into difficulty because the judiciary sees firsthand, as has been pointed out here by Mr. King, the judiciary sees firsthand on a daily basis the difficulties that the community encounters with respect to failed family relationships, drug problems, criminal problems of whatever nature, and judges being human beings driven by a desire to do something to solve this problem, probably seek to broaden the initial fundamental scope of powers, legislative and executive and judicial. You can't fault them for that, but it's very controversial with the legislature and with lots of others too, when courts get into extended programs that really mimic what should be executive department solutions, problems that the executive department and the legislature have seen, know exist, and failed to do anything about for a multitude of reasons. People, judges, courts will continue to try to solve these problems as best they can in the community, even though it does not fall within the classical concept of separation of powers. And it will be resented by legislatures too.
Thank you, Mr. McGraw. Ms. Walker.
I don't think there can be any dispute when you're looking at the state as a whole that the drug problem is not one of, if not the most important problem that we're dealing with. On any given day, there's a baby born at Ruby Memorial Hospital whose mother was addicted to drugs, which happens at hospitals all across the state. But we also have a lot of experience with being foster parents, because lots of times those parents will just leave the baby at Ruby Memorial Hospital. And DHHR, which is quite overwhelmed and trying to find homes for these little babies, sometimes just leaves them there because it's safe and they're getting good care, and the taxpayers largely are paying for it. That's just one example, but it's clearly a problem. The drug courts certainly are addressing, and the veterans courts and the juvenile drug courts are addressing folks who are already in the criminal system, but there is a lot to be done with keeping people from getting there in the first place. So I don't think any discussion about the challenges we have as a state can ignore the drug issue and the heroin problem. That being said, if you peel it away, what are other things that can be done? I can't help but think that we have to figure out a way to give some folks hope in West Virginia. It's a really tough time. You know, one of our major industry has been decimated, the coal industry, and now we've seen its impact on the state budget. So what are we supposed to do to try to find ways for West Virginia, not just to revive its budget, but to provide people some hope? And I think if we have a court that is not a judiciary, that is not an impediment to folks coming into West Virginia to start businesses, to grow their businesses, I think that could be a good thing. It's a there's not one magic bullet for the challenges we face, but I'm running because I think I can contribute to changing the negative perceptions, whether you agree with them or not, that exist about our judiciary and moving our state forward.
Thank you, Ms. Walker. Mr. Wooten.
Thank you. Question, as I recall, is problems facing litigants and lawyers within the court system?
And also the West Virginia legal system.
within our legal system. Well, obviously, the fiscal problem is a major concern that impacts the entire state. The Supreme Court's budget, the judicial budget, cannot be touched by the other branches of government, and that gives you some measure of protection. But some of the counties, especially southern coal counties, are going to have real trouble keeping people working in places like the county circuit clerk's office. That could have a negative impact on our system. Serious though the financial problems of the state are, the greatest problem facing our state now, and it permeates every aspect of our state to include the judicial system, is the drug problem. It is phenomenal. I applaud the efforts of the court to date, and especially circuit court judges and magistrates and family court judges that run drug courts. The judicial system is really doesn't have the scope to deal with the magnitude of the drug problem in this state. Other branches of government have to provide the leadership and the resources to deal with that. I don't know how it's going to be solved. It has to be solved, the judicial system has to continue to do its part. And if elected, I certainly pledge to pick up that mantle and do all that I can. With respect to problems that I think are peculiar to the judicial system, hopefully it will be some time down the road, but we're going to begin to have a problem with access to justice, given the amount of money we pay appointed counsel in criminal cases. Those fees were established, I think, more than 30 years ago and have not been changed. At some point, we're not going to be able to provide criminal defendants with their constitutionally mandated right to counsel. That has to be addressed in some fashion. That's not something that can be addressed by the judicial branch. That's a legislative problem, but it's going to impact the judicial branch. Another problem, we're going to have to go to electronic filing, more modern methods of record keeping, and I know there have been some efforts in that effort, but to me it seems like it's fits and starts. We've been at it for 10, maybe 12 years and do not have in place the system that we need to have with regard to electronic record keeping. Those are the two problems that I think are peculiar to the judicial system that we need to be concerned about.
Yeah, thank you, Mr. Wooten. We're nearing the end of our program this evening. I've got really time just to let the candidates here address one more question, and we're going to start with Mr. McGraw. And it's the same question, obviously, to everybody. And this is your closing argument to the people who are assembled here today, ladies and gentlemen who are assembled here today, as well as closing argument to the people who will be watching this broadcast on April the 10th. Mr. McGraw.
What is the question?
Closing argument why you should be elected as a Supreme Court Justice.
Such a comment would require one to be self-serving in a way that is very uncomfortable. I have a crutch, and it is drawn from the commencement program of West Virginia University this last graduation. The law school at West Virginia University awarded me the Justitia Officium Award, which is represented to be the highest award of the law school at West Virginia University. And they said in the program for the graduation as follows, and I'm going to read. At the Supreme Court, McGraw established himself as a progressive jurist. A few of the recognized landmark actions of the court during his time included the 1978 Mandelitis decision, which recognized the rights of injured workers to hold intentional violators of workplace safety laws accountable, the mandating of proper funding of public education, the enforcement of human rights law, and the obligating of proper funding for public pensions. In 1972, McGraw was elected Attorney General of West Virginia and served 5 terms in that office until 2013. The Consumer Protection Division under McGraw was greatly expanded, received national recognition, and for 2 decades it engaged in exemplary work recovering multi-millions in dollars on behalf of West Virginia's consumers, especially the elderly and the most vulnerable. That is my record. It is my opinion that one can predict my future conduct to a considerable degree based upon my past record, and upon that record I base my request for you that you vote for me for Supreme Court Justice of West Virginia.
Thank you, Mr. McGraw. Ms. Walker?
Let me thank all of you in the room, and I suppose anyone who's viewing us in the future on television for the opportunity to be here today. I'm committed to the future of West Virginia. I've been extraordinarily lucky, in my view, to have the opportunity to practice for a great law firm and now to represent a great hospital system. But I think, as I thought in 2008, that it's time to give something back. And something that I can offer is a commitment to being a fair and impartial judge who's simply going to follow the rule of law. I want to work hard at that. There are a lot of important issues that are policy matters, but the Supreme Court, first and foremost, needs to just judge. You know, we run into some problems, and we have in the past with our Supreme Court, when Supreme Court justices feel it's their job to impose their personal policy preferences or their personal views on legislation, for example, second-guessing the legislature or legislating from the bench, as it's often called. I think that's a tremendous problem. The legislature needs to do its job, and the Supreme Court needs to be a separate, independent branch of government that, in my view, is divorced from politics, that is committed to working hard, to treating people respectfully, and to improving its reputation, and ultimately helping to improve the state of West Virginia. And with that, I ask for your support and your vote.
Thank you, Ms. Walker. Mr. Wooten?
Thank you. I think the Supreme Court is best served by lawyers that have functioned as lawyers. I have the experience that I believe the job requires. I've been involved in practically every type of case one can have in this state, and I've appeared in practically every type of court there is in this state. I think that experience will be invaluable. It requires scholarship. I did very well in law school. I was top of my class, editor-in-chief of the Law Review. I can bring that talent to the law school. I've got a demonstrated record of public service. I'm committed to doing all that I can to improve the future of our state. During my time in the legislature, I'm very proud of that service, and I'm proud of the fact that no one ever questioned my impartiality, my fairness, my integrity, or my honesty. I think those traits of character are what are needed on our Supreme Court. And for those reasons, I would humbly ask for your support and your vote. Thank you.
Thank you, Mr. Wooten. Mr. King?
Approximately 1 month out of law school, I was arguing a felony case in front of the jury in Clay County in front of Judge Duffield. That time it was something like $50 a case for your felony cases, your misdemeanor cases, and when you appealed one, the Supreme Court said, "Thank you very much for doing a good job." At least now we're up to $45 and $65 an hour, and I agree with Mr. Wooten, something has to be done with that. For 45 years, I've been practicing in Clay County and across the state of West Virginia. I've handled cases of all type, criminal cases, prosecuted criminal cases, defended criminal cases. I've been a plaintiff in cases against major corporations, some successful, some unsuccessful. 50% of the lawyers lose. I've got my pretty good share of that 50% on the losing side too, I'll tell you. So I know how it feels to win and to lose. And I've had parents come up to me and thank me for defending their children, write me a letter and thank me for defending their children. To hear someone tell me that they're proud that I was a co-counsel with them or something, it really means a lot to me. We have a great bar here in West Virginia. I feel that my experience, totally, I've tried more cases, I believe, in front of a jury than all these people put together. I believe if you add them up, I have. And I think that gives me a unique insight to the court system in West Virginia. People ask me, what is my judicial philosophy? I don't know. I can only tell you that the best decision I ever made in my life was marry my wife. And that's the best decision I ever made in my life, and I'll try to follow that same course in being a justice for the Supreme Court. Thank you very much.
Thank you, Mr. King. Justice Benjamin.
In my 12th year now of my 12-year term, I look at a court that is stable, is predictable, is fair, is collegial, and I'm proud of that. That is the record that I bring to the voters. That is the record upon which I wish to build in the next term. That is what can be expected from me as a justice. In addition to being a fair judge, in addition to being independent, which I think all judges must be, I've also shown leadership in leading the expansion of drug courts to deal with the drug problem, even when it was not an easy thing to do 11 and 12 years ago. I've led the effort to expand veterans courts, juvenile drug courts in our state. Listening to the problems that I was hearing, we started looking into a thing called business court, and now it's a very successful program. Being a justice is about being a fair judge, but it's also about leadership within the judicial community and the legal community. My record speaks for itself. It is the record upon which I run. It's a record upon which I'm very proud. I therefore ask for your support and your vote on May 10th, and you can follow us more at justicebenjamin.com. Thank you very much.
Thank you, Justice Benjamin. Please join me in a round of applause for our candidates here. Certainly appreciated their candor and their insights too. There is a reception next door that will start immediately at the after I am finished here. Please attend the reception. Let me also remind you that upcoming events sponsored by the West Virginia Bar Association, and that's the Business and Real Estate Conference. It's going to be held on May 21st. It will be at Stonewall Jackson Resort. The 130th annual meeting of the West Virginia Bar Association will be had at the Homestead, and that will be on August 4th through the 6th. If you're not a member of the West Virginia Bar Association, please pick up an application when you go out the door. Now, you don't have to pick one up to go next door for the reception, but you certainly make a lot of us happy. Thank you, everyone, for your attention this evening. Remember to vote on May 10th. It's the only time you get to vote for this office here. And again, have a great evening. Thank you.